Hey there, Kevin. It's great to be back with you on day 4 of the Julian Assange extradition hearings. You have just left court for the day. Why don't you give us a recap on what we saw happen today?
Not only did I leave court for the day, but I've left court for this month, and I probably won't be back here until May and June. So the fact that the way the proceedings ended today was with the judge, and her name's Vanessa Baratzer, and she ruled against a request made by the defense for Julian Assange to have and allow Julian Assange to sit with his attorneys during proceedings because he's having difficulty participating in the proceedings, and he would like to be able to confer with his attorneys privately. He's very concerned that his private conversations with attorneys are being eavesdropped on and that they aren't confidential. The 2 security guards that stand by him while he's in court. And let me just backtrack. Every morning when he comes into the courtroom, he enters this glass box that's in the back of the room. For people who are not from the UK, or for primarily the audience of people watching this broadcast that are in the United States, we don't put defendants in a glass box in the United States. And that's happening in the courtroom here. It was apparently, according to the defense, something that sprouted up in courthouses 20 or so years ago. It's not like this has always been the way that the United Kingdom handles proceedings, but part of security is to place the defendants in a glass box in these higher profile security cases, I guess. And then so it just happens to be that they're availing themselves of this to place Assange here in this box during the court proceedings. And so Vanessa was essentially asked, could you allow Julian Assange to sit with the attorneys? And the request was rejected flatly, very flatly. There were multiple arguments made related to how it's standard procedure to allow somebody to do this if they are struggling, to allow a defendant to sit with their attorneys. And as it turns out, none of those really mattered or made much difference to the judge. There were things that were said about how there are poor acoustics in the courtroom, so he can't hear. Things said about how it's difficult to pass notes between him and his legal team because of the fact that they are not able to alert each other when they want to make an exchange of a note. The defense is facing the judge, and then Julian Assange is directly behind him. It's not like he's in their peripheral vision or anything. So when there might need to be a passage of a note, or when there might need to be a small conference in the middle of a proceeding, there's really no way for the defense team to know that that is something that Julian Assange is requesting. And there's other aspects of here that we could get into, other details that I could talk about. But the fundamental thing is that the accused does not believe that his rights are being protected fairly, and does not trust that his communications are not being eavesdropped on because of what went on in the Ecuador embassy when Undercover Global, as we heard about this past week, targeted the Ecuador embassy in an espionage operation and eavesdropped on the conversations of attorney-client privileged communications, and was eavesdropping on these meetings, and even going so far as to eavesdrop on meetings that were being held in a women's bathroom in the Ecuador embassy. And yesterday, according to Assange supporters that were in the court and people who heard him speak in the courtroom when he stood up, he was mentioning that there were people he knew from the Ecuador embassy who were at court. And he recognized them, I presume, and not feeling comfortable to speak with his attorneys if what he's saying gets picked up and they're able to hear it, and then maybe pass on his own comments to the U.S. government, or pass it on to individuals that may be able to use that information against him. There's a fundamental issue of whether he's being able to put together his case, his defense case, without being put under this kind of threat of the government knowing exactly what they're going to do so then that they can rebut it. I mean, the whole idea is that he should be able to privately put together a defense without the prosecutors knowing ahead of time what they need to do so that their prosecution won't be challenged.
Thank you, Kevin. And I think, pursuant to a conversation you and I had earlier, I think it's just worth pointing out that Assange hasn't been, he's not being extradited on charges that involve violence. There's probably no real escape threat for Assange, especially given his health and the condition that he's in. Just wanted to underscore how absurd this whole situation is. And I'm glad that you point out sort of the effect of it in terms of denying him his rights at trial and his ability to speak with his attorneys. Go ahead.
Well, and the other thing to add here, again, the United States government comes out looking pretty good because the prosecutor is okay with Julian Assange sitting with his attorneys. And Mark Summers was the defense attorney making the argument to the judge that Assange should be able to sit with his legal team. There are also other people who are past defendants in UK courts who I understand were mentioning on Twitter that they were allowed out of, okay, I call it the glass box. It's a glass box, but formally it's known as a secure dock, and that they were allowed in and out of the dock to be with their attorneys. And so the US government's okay with Julian Assange sitting with his attorneys, but the judge is, I guess politically you would say to the right of him because then, you're putting it in authoritarian terms. But the thing is that she just is essentially saying this is the procedure for the court, and I'm not going to let Mr. Julian Assange alter the procedure that we have developed for this court. And then meanwhile, the prosecutor and defense, as we were wrapping up the final proceedings for today, I could overhear them on a microphone during break talking with each other about how unreasonable they think the judge is being, because it is actually part of standard procedure to allow the defendant to be with their attorneys if in this case he is struggling to participate. I repeat that in making this request, Mark Summers, the defense attorney, cited multiple examples of similar cases where if you're hard of hearing and you can't follow proceedings, or you have some kind of mental instability or mental health issue that is getting in the way of your participation, those kinds of things, which they say that Julian Assange is struggling with, should be good enough to force the judge to allow you to be with your attorneys. But it was remarkable that they said that his vulnerability as a defendant was something that added to the burden that he's going through. And then she came back and said, well, you really haven't put any evidence on the record to suggest that those struggles, those issues you're having with mental health are something that are getting in the way of you being able to hear and follow these proceedings.
Thank you. If you have any other comments that you'd like to make about this aspect of the proceeding, certainly please do so. Otherwise, I would love to hear, and I'm sure everyone out there listening would love to hear some of the arguments that were made in court today, what the focus of the proceedings was today.
Yeah, so before this, we finished up some argument over political offenses. The political offense exception, which we got into on the third day of proceedings. This was the day for the prosecutors to wrap up their argument. They did get to start it yesterday, but it didn't last very long. And then again, towards the end of the day, around 4 o'clock, we had Julian Assange rise up and say he had basically had enough of proceedings for the day. So the prosecution was cut off and was not allowed to continue. So we came back today and they went into it. And, the thing that I really walked away with was that, and this was partly brought out yesterday, and I wrote about this in the report that I filed for Shadowproof, which you can go read. But essentially, they're making this argument that the United States, United Kingdom extradition treaty that was established does not have as much force of law as the domestic law in the United Kingdom, that statutorily the judge is supposed to be primarily concerned with what the Extradition Act that is in force in the UK has to say. And when it comes to the political offense exception in the law, it is silent. They took out the part that used to speak to the political offense exception issue. And so they are hoping that the judge only looks at this domestic law when making decisions on whether to allow the extradition of Assange. And then they believe that this will enable the judge to ignore all of what the defense is putting forward and asking her to pay attention to. And then that'll work in their favor. That'll help the prosecution win extradition to the United States, because they're no longer able to say, oh, this is a crime of espionage. Espionage has typically been considered a political offense, and so therefore he should not be extradited. Or the way that the indictment is laid out, it accuses Assange of a crime against the state. It suggests that he's hostile to the U.S. government. That sounds like a political charge. Therefore, it's not extraditable under the treaty, and so he should not be extradited to the United States. They're trying to get around international law and say this treaty is not something that has any force of law in the United States. I think that's hugely problematic. I hope to do follow-up on this in the coming days and maybe speak to some of the representatives of human rights organizations here in the United Kingdom to ask them how they feel, because it certainly seems like to an observer that they're blowing a hole in human rights protections in the United Kingdom by suggesting that there's this loophole in which you could argue the treaty does not have some kind of protection that would protect you against arbitrary detention or enable you to have some protection in the way of due process rights as it relates to being extradited, as it relates to an extradition request, and in this case, particularly from the United States. So that was what we heard from the prosecution, is this argument that was outlining why they believe the defense does not have solid ground to stand upon when they raise the political offense exception. And I'll make it clear, I don't know if I've done a good enough job of making it clear in the past few days, but it was actually said by the defense clearly today, and I'll repeat that the defense has the burden in these proceedings to prove that the extradition should not go forward. The prosecutor essentially can sit back and let this unfold, and if there aren't any reasonable objections, then the extradition we would expect to be approved by the judge. In the afternoon, or right before lunch, the defense had the opportunity to get up and reply to what the prosecution had just said. So to rebut the prosecution's rebuttal to the defense. And I will just very generally summarize the aspect of what the defense said that I thought was most crucial, which is that they, in fact, can clearly articulate that WikiLeaks existed as an organization and that Julian Assange was focused on inducing a change in public policy. There was this exchange between the judge and a defense attorney over, whether, in fact, they would be covered as a kind of organization that was involved in trying to change politics in the United States. She said something to the effect of, well, they're just publishing information about corruption and wrongdoing. And specifically in this law, it points to individuals who are involved in political struggle. Historically, this political offense exception has been useful to dissidents or activists who wanted to avoid extradition for crimes that were being brought against them, I'd imagine, by their own state governments who wanted to prosecute them for being enemies of the state, or as they would probably describe them, are people who were opponents of the state. And they had this exchange back and forth where the defense asserted that WikiLeaks has primarily existed to change public policy. And they went down the list, pointing out that the Iraq war logs and the Afghanistan war logs were to call attention to civilian deaths, that the publication of the collateral murder video, as well as rules of engagement file on the way that the Iraq war was prosecuted, was published because WikiLeaks wanted to call attention to the fact that war crimes were being committed and rules of engagement were not being followed by the U.S. military. that the U.S. diplomatic cables were to be published in order to affect change, and in fact did affect change, that they already are, like the U.S. government says that they're opposed to the Afghanistan war. So if the perception of the U.S. government is that the WikiLeaks organization is opposed to the Afghanistan war, then publishing the Afghanistan war logs is an act of them trying to change the policy, trying to force the end of the Afghanistan war. And that, in fact, the publication of a cable from the Cablegate release did lead to the withdrawal from Iraq of U.S. forces, did spur the withdrawal of forces from Iraq, that Obama wanted immunity for U.S. troops and was trying to make this a part of a status of forces agreement. And then because a cable was released that had evidence of war crimes that occurred in Iraq involving U.S. soldiers, there was no longer an interest in the Iraqi government to allow immunity for soldiers that were going to remain as a residual force in Iraq. And so that sped up the withdrawal of forces from the country of Iraq. I think back in, this was around 2011, I believe. So this was what happened in the morning. And then we already went over the afternoon, where we were primarily focused on what was going to happen with Assange, whether he would be able to join his attorneys. And that's how these proceedings have ended. I'll have an opportunity in the next day or two to sit down and have do some kind of a video where I go over what just happened these last 4 days, try to pull out some more bigger picture ideas and assess what this might mean going forward in its entirety. What's coming up next in May and June, as I understand, is an evidentiary hearing. So comparatively, this hearing that you've all been following my reporting on revolved around legal arguments in this extradition case. And then this future hearing that will be 3 weeks, we are going to hear from witnesses who are going to take the stand for both the prosecution and the defense to provide evidence that will be for and against extradition. This is going to be a very important proceeding to be covering. I am looking forward to being here to report on this proceeding, because we're going to hear from people who can share the revelations about the undercover the Spanish private security companies spying on the Ecuador embassy. We're going to hear about Julian Assange's health. I think some of that's going to be really heavy to listen to as they dig into his deterioration and what has happened over the course of him being incarcerated, being held in detention. And we're going to hear evidence related to the disclosures and the claims that he solicited leaks, the idea that he doesn't care about lives, that he's reckless and endangered people when he was publishing these materials. There is going to be a ton to go over and deal with, but not to get ahead of myself, I want to thank Brian for all the support that he's given me while I've been on the ground here in London, because I could not have done a lot of this without him. He's been somebody I can contact and get help with editing my articles and doing this stream and these video reports for you. And also, I want to say thank you to everyone who's been following my reports on proceedings. I am so glad that there are people out there that support this independent work that I'm doing. Today, it was brought home how important it is to have someone who's an independent journalist at the courthouse, because on this final day of the proceedings, I think you could count on one hand, one single hand, the number of people here from the United States that were covering this case. I spoke to someone. We did not know if AP, the Associated Press, or Reuters even had their journalists here. They do news wires. They are crucial in pushing out stories to the media about these types of cases. And I didn't see them today. I noticed an NBC News producer, but by and large, I'm not sure who was here who is an American journalist. Those people were missing in action. But we were here. Shadowproof was here. I was here. And I'm going to be here next round to cover these proceedings. But that's only possible if you chip in and donate. So for those of you who appreciate these reports that you've been hearing, if you can, $1, $2, $3 even, every little bit adds up, and it is helpful in ensuring that we can continue to report on this case that has a lot of stakes for not only press freedom, but freedom of expression. And as was brought home today, whether the rights of the accused are going to be respected when they go on trial in courthouses that were built for counterterrorism.
Thank you so much, Kevin. I know that I speak for a lot of people out here when I express my appreciation for the very thorough reporting that you've been doing. I'm very glad that you've been able to be there for the entire proceedings for this week. And I am very excited to send you back in May to cover the next round. And I'm confident that all the folks out there who are reading and who have donated will continue to support and make sure that we can send you there and cover your flights to and from Chicago to London and your lodging. It's a big trip. It's a lot of work. You're covering a very complex case with jet lag and a whole nother country. And I just wanted to commend you for the excellent job that you've done. So thank you very much.
So one more thing before we go.
Yes.
Just a couple things for you. Well, first, I want to show people something. So back here, behind here, we've got, I just want to let you know that back here, we've got people who are intense supporters who have been here. And then out in front of this courthouse, what you can overhear in the background are the Julian Assange supporters who have been here every single day chanting. And there are people from multiple different countries in Europe and then from other places of the world who have been talking about, have been here doing these chants and showing their support for Julian Assange. One thing that I haven't talked about on a daily basis, but I'd like to make sure people know before I conclude this week, is that it's exceptionally difficult for the public because someone in the press who wants to go in and witness proceedings can show up about a half hour or 40 minutes before the proceedings are to take place. And then you can go in, you can sit down, and it's very easy. For members of the public, there's very limited seating, and there's only about 16 or 17 spots that people can sit down in. And you have to compete for your spot there. You have to get there first. So people are waking up 3 and 4 hours before the court even starts at 10:30 just so that they can get a spot in this courtroom. They have not expanded the number of seats. I'm not sure that there's any plans to have some kind of a live stream in the courthouse so that more members of the public could be in there. There are more people who are supporters who would like to be there to watch Julian Assange. So I think that goes to the way that the court is conducting these proceedings and whether they are fair and whether they're open to the public and transparent. I don't know if there's going to be any effort to change what is done. So we'll see going forward in May or June if there's any push on behalf of the public to allow more access for people. Because as of right now, 16 people get in, and there's anywhere from about 50 or 60 people here on any given day who would like to be in there to witness what's unfolding with Julian Assange. So with that said, again, I thank you all. And one more thing I'd like to say is the end of these proceedings where the judge decided not to accommodate Julian Assange and give him a place at the table with his attorneys during the proceedings is crucial because she started talking about how they could just have frequent breaks and he could go, they could go out and they could talk with Julian Assange and then they could come back and they could keep doing this every couple of hours. And they talked about how they could start court later in the morning. We could start at 10:30 instead of 10. All of this is going to make a 3-week hearing longer than already planned, which is where I say I'm going to make plans based on what I know are possible. And I'm going to schedule my flights. I'm going to book my hotels. I'm going to arrange my travel to and from this courthouse, do what I have to do. But that might change. And then because it changes, there will be incidental expenses. So the judge not respecting Julian Assange's rights has an effect on independent journalists like me and everyone else here who are trying to manage resources. And I'll say, like, it's really hit home for me in covering these proceedings, the disparity between establishment media journalists and independent media journalists. These establishment media journalists are backed up by money. They have corporations that fund them. They can get there. But the journalists that go to cover Julian Assange are assigned. I'll say that again. They are assigned. They do not know a whole lot about these proceedings. They do not necessarily want to be there. They are told by somebody that you are going to be covering Julian Assange today. I am here because I want to be here. I care about this case. I've been digging into it for 10 years, and I don't have any doubt in my mind about what's going on, and I don't need to ask anybody else to help me understand what's going on in these proceedings, nor do I feel like I'm being forced by my editor to be here to cover Julian Assange. And I frankly care about what's at stake in this case. So I'll just throw that out there because I think it's a little bit, I don't know, it gets a little under my skin that these establishment media journalists have the luxury of deciding when and where and how to pick up and leave, and they can afford to just come and go as they please. If they want to be here from Monday to Tuesday through Wednesday, they can just be here on Monday. They could be here all week. It doesn't matter because someone back at headquarters in their tall building is going to give them whatever money they need to make whatever choice they would have to make. And we don't get to do that. But nor are we going to selectively decide what to cover. We're going to cover it all.
Thank you, Kevin. That was very well said. I think that last point is crucial. And, unlike a lot of establishment journalism, we don't show up for the first day and then leave. We're going to be there for the whole thing. So I think that's absolutely crucial. Unless you have any final thoughts, I think we should leave it there. I think that was very well said.
That's great. Well, again, thank you all.
Thank everyone. We'll talk to you soon. Stay tuned for more reports from Kevin. He'll be filing probably another report tonight and over the next few days as he talks to people. And thanks once again for tuning in and supporting, sharing, donating. We couldn't do this reporting without you. So thank you.